Thank you, Mr. President. On rising to place my comments on the public record regarding the Environmental Management and Pollution Control Amendment Bill 2022, I must say I find myself thinking that this is something of an odd bill. On the one hand, at a macro level, it seeks to deliver on an important measure that many in the community have been calling for a considerable amount of time, an independent Environmental Protection Authority. However, on the other hand, it has all the hallmarks of an interim, I think, stopgap measure, producing an EPA that's not actually as independent as many in the community may have felt they understood to be promised by the government's commitment. Following the gazettal of the State Service Restructuring Order No. 2, 2021, on Friday, 26th of November last year, the Environmental Protection Authority formally separated from the department on December the 1st last year. And the Minister stated during House of Assembly budget estimates on the 8th of June this year, and I quote, "To further support that separation and bring greater transparency to environmental regulation, we are proposing amendments to the Environmental Management and Pollution Control Act. These amendments will further strengthen the independence of the EPA and its statutory assessment and regulatory functions and clarify the powers of the Director." That was in the budget estimate session from the Minister. This bill appears to be all that the government is proposing to progress in order to formalise that independence of the EPA. I don't believe there's other measures to come. And hence I think there's a sense of disappointment from some key stakeholders and others around the degree to which this achieves the expected outcomes. The words sounded very positive, but the legislative reform is relatively minimal. Mr. President, the second reading speech delivered by the Leader for the Government here lists 3 key areas of reform contained in the bill to deliver the Minister's stated intent, with the contention being that those key areas of reform will, and again I quote, "play an important role in protecting Tasmania's environment. It will also mean the public can have greater confidence in activities that use the state's natural resources and oversight of those activities." Mr. President, the fact there is a loud and legitimate call for a truly independent statutory authority as the state's EPA is acknowledged by the government, promising to strengthen the independence of the EPA, which makes the fact this bill misses that opportunity to deliver so, I think, frustratingly and potentially bitterly disappointing for many. To be clear, the limited parameters by which the government set itself to work on this reform was of its own choosing. It could have broadened those parameters and consulted on a comprehensive review to deliver that long-awaited standalone statutory independent EPA. Yet that's clearly not to be, or at least not yet. Therefore, we're left having to evaluate this bill against the limited goals the government set itself. So, Mr. President, instead of a statutory independent entity, the revamped EPA as envisaged by this bill is described as a state authority by the government. It's specifically referred to as a standalone state authority on page 4 of the explanatory paper for consultation draft, which was provided with the draft bill. And I asked for clarification on that designation in our briefing on the bill and was pointed to the State Services Act 2002 for the definition of a state authority. And this is what it said in that Act. State authority means a body or authority where, whether incorporated or not, which is established or constituted by or under an Act or under a royal prerogative, being a body or authority which or of which the governing authority wholly or partly comprises a person or persons appointed by the Governor, a Minister or another state authority, but does not include a government department. I also noted in the Tasmanian Audit Office document titled Reporting by Tasmanian Public Sector Entities the following description of a state authority. A state authority is not a government business enterprise. What constitutes a state authority is quite broad. Any entity that is not captured by one of the other more specific categories will most likely be a state authority. And then it quotes the Audit Act definition and goes on further to say this. This definition is quite all-encompassing, not only capturing many larger, specifically created public sector entities, but also the many smaller trusts, boards or management authorities. For example, the Theatre Royal Management Board. Mr. President, as well as the Theatre Royal Management Board mentioned in the Audit Office document as an example, I heard in the briefing that state authorities also cover entities such as Brand Tasmania, the Integrity Commission, Macquarie Point Corporation, possibly the Port Arthur Historic Site Management Authority, although I note that's referred to and described as the GBE elsewhere. So in a nutshell, Mr President, my understanding is that a state authority is a very broad label. It's basically a catch-all, which indicates that while still under state service management, the entity is not within a department, but sits perhaps adjacent, if you will, to any department. So calling this new EPA a state authority doesn't tell us much about its degree of independence or give us much detail in terms of its characteristics. Mr President, on the one hand, it should be self-evident. However, it cannot be stressed enough that at the core of securing greater public confidence in our environmental governance and regulation is the genuine independence of the EPA. In this regard, as stated by the Environmental Defenders Office, the EDO, in its correspondence to members here on the 7th of November, this bill is, and I quote, a missed opportunity to provide for the best practice environmental regulator, which, given the expansion of industries such as salmon farming in our precious coasts and inland waterways, is sorely needed to protect the places Tasmanians love. End of quote. Members here may recall the Legislative Council Subcommittee report on finfish farming in Tasmania presented findings and a strong recommendation relating to environmental governance, including the need for independent, transparent and accountable regulation of the finfish industry by an independent EPA. We heard through that inquiry a resounding call for that in the evidence presented. And clearly the independent, transparent and accountable regulation called for in relation to finfish farming is required just as much across other industries and activities in this state. So, Mr President, I think it would be good to have clarified by the Leader just what is meant specifically when the government describes the EPA under the provisions of this bill as independent. What are the specific ways this new model has a greater degree of independence than the previous model in exercising the functions and powers that have been and continue to be the legislated functions and powers of the EPA Board and the EPA Director? The Minister's second reading speech states that one of the key things the bill does is it completes the legal separation of the EPA from the Department of Natural Resources and Environment. And further, the second reading speech closes with the bill provides the legal foundation for a contemporary proactive approach to these matters in line with equivalent national legislation. So I'd like the government to explain the difference between legally separate and independent, if there is one. And is establishing a legally separate EPA the first step towards a fully independent agency, such as an independent statutory authority, or something equivalent to what we might see in some of those independent EPAs in other jurisdictions? Moving on, Mr President, as noted in the EDO's submission to the consultation on the draft bill earlier this year, the mere existence of an independent EPA does not in itself guarantee the environment will be better protected, nor that development will be regulated appropriately without undue external influence. The EDO in that submission warns that an environmental regulator established without sufficient independence mechanisms, a lack of clear legislative criteria for decision making, and with a specific focus on realising economic objectives, can lead to significant resource expenditure without corresponding improvement to environmental governance outcomes. To be effective at truly improving environmental governance and environmental outcomes, an independent Tasmanian EPA must implement a comprehensive suite of strong governance measures. And to inform ourselves on that point, I look to the National Environmental Defenders Office Best Practice EPA report, which outlines 9 elements of strong governance. These 9 elements state that all EPAs should have the following. 1, have a duty to develop and act in a conformity with cultural protocols which are based on First Nations law and to uphold internationally recognised First Nations rights of free, prior and informed consent and self-determination. 2, be underpinned by environmental justice frameworks that acknowledge and address environmental racism and meaningfully define environmental justice, legislatively enshrine mechanisms to achieve environmental justice and have a proper foundation in principles of human rights under international law. 3, have a clearly defined role and duties to ensure objectives are achieved. 4, be established as an independent statutory authority that has a clear independent governance structure supported by a board to provide strategic advice and direction, freedom from ministerial influence or being overridden by other agencies, policies and procedures to manage conflicts of interest. 5, be accountable to the public, which includes well-defined and clear criteria for decision-making, mechanisms to review decision-making, including open standing for judicial review and merits review, the regular publication of State of the Environment reports, and powers to scrutinise performance, both the government and itself. 6, have transparency in decision-making through disclosure and community engagement to support accountability. 7, be sufficiently empowered to protect the environment and human health. 8, have sufficient and certain funding to fulfil their functions. And 9, hold relevant expertise to support decision-making that's science-based and provides First Nations justice and environmental justice broadly. Mr President, I know that's a lengthy list, but I think it's important that this is work done at a national level to identify the elements that need to be there, the 9 elements that need to be there to ensure there's strong governance in an independent EPA. And when evaluated against those required elements of an independent EPA, this bill, I believe, falls short, considerably so. It's beyond the scope of the debate to go into exhaustive detail of what I think are missed opportunities here, but I will focus on just a couple of key areas. Mr President, the first in an environmental justice framework is something I'd like to point to. An independent EPA should be underpinned by an environmental justice framework, according to those elements laid out at a national level by the EDO, to ensure that equality in environmental protection is there, and it's not provided for here in this bill. A key related absence here is any inclusion of the need to develop and act in conformity with cultural protocols developed by the Tasmanian Aboriginal community and to uphold internationally recognised First Nations rights for free, prior and informed consent and self-determination. I'd be interested to hear from the government what consideration was given to the inclusion or reference to some form of environmental justice framework alongside the establishment of an independent EPA. Mr President, arguably, if we look at the element of defined principles and role, arguably this bill misses the opportunity to provide the EPA with a clearly defined role and duties to ensure objectives are achieved. Again, a quick canvass of EPAs around the nation reveals that many have a clear set of principles or objectives outlined upfront in their respective establishing legislation. These boost public confidence, something this government has stated it's keen to foster here as well, by providing clear criteria and expectations against which the EPA's actions can be directed, seen and evaluated. In some interstate cases, it's clear that the inclusion of legislated principles and objectives replaces any equivalent ministerial statement of expectations. In fact, when it comes to principles and objectives, I do wonder where we can find it plainly stated in this legislation, or the primary legislation, that it's the primary responsibility of the EPA board and EPA director to protect the environment and human health, consistent with the human right to a healthy and safe environment, which you'll recall was one of those elements the EDO at a national level considered essential for an independent EPA entity. Mr President, it should go without saying that the EPA should be independent from ministerial influence, that of other government agencies or industry capture. However, to protect both the public interest and the EPA itself, this independence from ministerial influence should be clearly codified in legislation. But we can all see from this bill that that will not be entirely the case for Tasmania's EPA. The role of the Minister is still heavily entwined through the governance model, from the statement of expectations through to making, amending and revoking the environmental standards. I'm interested to understand what consideration was given to a model such that we might see in another jurisdiction where there is less involvement through the governance elements of ministers. Mr President, the government's second reading speech mentions providing certainty on the role of an independent EPA director. And I have some questions regarding the independence of the EPA director under this model, particularly given the requirement of Section 18 of the Principal Act that states, and I quote, it's Section 18, Director, Environment Protection Authority, The Governor may appoint a State Service Officer or State Service employee to be Director, Environment Protection Authority, and that person holds office in conjunction with State Service employment. Now, that's in the Principal Act, Mr President, and it's not being amended, I don't believe, by this bill. And I find it interesting. So the director, EPA director, is going to be a State Service Officer holding the office in conjunction with State Service employment. I note that that's different to some of the other statutory positions that we have in this state, say the Auditor General, the Anti-Discrimination Commissioner, the Chief Integrity Commissioner. They are all a bit different, of course, in their establishing legislation. But the common factor is they are not, I don't believe, State Service employees in their roles. So what I'm interested to know more about is, can the government provide some explanation on the nature of the Director EPA position under this model? Is it analogous to any other statutory positions that we might look to in other areas? How is it not? The question I have, I guess, is how is it not inconsistent with the commitment of delivering an independent EPA if the director is a State Service employee or officer, basically an employee of the government? And I'd also like to know if this is an arrangement that corresponds to other jurisdictions for their equivalent positions. Is it a model that we can look to elsewhere to see? Mr President, I also note the bill misses the opportunity to provide the EPA board with a role in appointing or providing oversight of the performance of the director's functions and powers under the Act. I note that in Victoria, the EPA board there, under their model, has the power to do the appointing and then providing the oversight of the CEO of the Victorian EPA. That role is equivalent, I believe, to our director's role. So I'd like to understand from the government or have an explanation as to why the EPA governance structures were not addressed in this bill in terms of the relationship between the board and the director. For example, why is the board not responsible for the employment and appointment of the director or supervision of the director? Or perhaps I've misconstrued that and there is more of a direct role there. Perhaps the government could provide an explanation. Similarly, Mr President, there was an opportunity, I think, in this bill to detail the EPA director's functions or powers quite explicitly, just as Section 14 of the Principal Act details the EPA board's functions and powers. We don't seem to have an equivalent description of the EPA director's functions and powers. I'd note that Section 8 of this bill, which inserts Section 18A, independence of the director, into the legislation, specifies the instances in which the director is not subject to direction from anyone in relation to specific decision-making powers, and it lists the types of decisions that the director has independence under or within. And in a way, perhaps that Section 18A that's being inserted with that list becomes a de facto list of the director's functions and powers. But it isn't necessarily presented as a clear and exhaustive list of those functions and powers, and I'm not clear on why there's not a straightforward articulation of those. So perhaps the government could provide an explanation of why that isn't the case. Mr President, significantly, I also note the bill fails to provide a process for the management of any arising conflicts of interest of the director. We would all recognise this as a pretty critical aspect of any system of good, transparent governance. Certainly some of those other statutory roles that I mentioned earlier have something specific in their establishing legislation that deals with conflicts of interest. And we've seen it before in other legislation for particular entities or roles. So I'd like to understand why the government has failed to address that in this legislation. And in its absence from the legislation, what would be the arrangements for the identification, the documenting and the transparency around managing conflicts of interest that may arise in relation to the director? It's also worth noting, Mr President, that the National EDO report on effective independent EPAs, which I talked about earlier, states under that recommendation 5 as an accountability mechanism to ensure responsibilities are discharged with integrity in the public interest, that a State of the Environment report should be published regularly by the EPA. have to say I find it astounding, given the recent controversy over Tasmania's missing State of the Environment reports, that there does not appear to be any consideration provided while developing this bill to finally house the State of the Environment report within the further independent EPA. Particularly since the recent announcement by the Planning Minister, Mr Ferguson, that announcement carefully states that the Tasmanian Planning Commission has so far only been directed to produce the next State of the Environment report in 2024, leaving open where the responsibility for any future State of the Environment reports will lie. Interestingly, with the Northern Territory aside as the only jurisdiction without a requirement to produce a State of the Environment report, we can look to other jurisdictions and see in New South Wales, WA and South Australia, where they have State of the Environment reports all as responsibilities of their respective EPAs. In the case of Victoria, they have it as with their Commission for Environmental Sustainability, and Queensland locates it State of the Environment reporting responsibilities with their Department of Environment and Science. But the EPA is certainly a common location for that responsibility. I do wonder whether this bill is a missed opportunity to signal that the uncertainty over our State of the Environment reporting in Tasmania has been resolved once and for all by allocating that responsibility for producing the report with this new independent EPA. And then, of course, what would follow would be an assurance of adequate funding capacity to undertake that task, one would hope. May well be, Mr President, that comes to pass in time, and it's just that decision making around it hasn't been able to be completed within the time for bringing this bill forward, which may well be the case. We may find at some stage down the track that responsibility does arrive at the door of the EPA as configured under this bill. Mr President, as we all know, independent statutory entities must still be accountable to the Parliament and to the Tasmanian public. And while there's some provision in the bill for the EPA Director to publicly release information and data in a more transparent way, reporting to the public and direct review of the EPA itself seems to be fairly light on. For example, currently the Minister is required to issue a statement of expectations to the EPA every 2 years. Clause 6 of this bill, Section 15 amended, now intends to extend that timeframe out to 5 years. Now, there's some debate, I think, about whether there even should be ministerial statements of expectations given to a truly independent statutory agency. Perhaps a truly independent entity shouldn't be subject to ministerial direction in that way. But given the model we have presented, I would be interested to hear what consideration the government gave to a fully independent EPA that would not be subject to ministerial statements of expectations, as per some of those interstate jurisdictions. And of course, it could be argued that in the absence of a clear set of principles informing the EPA's actions and priorities, the statement of expectations from the Minister remains a form of parliamentary accountability. But the point here is that extended timeframe from 2 years to 5 years potentially leaves concerns over the risks of those expectations becoming outdated, but while still remaining in effect. I understand that they can be brought forward and reviewed at an earlier stage, but it's interesting because I think it's worth noting the most recent ministerial statement of expectations that we have currently, and then the EPA Board's corresponding statement of intent against that statement of expectations appears to be expired. So we're currently outside of a period that was defined as being covered by the current statement of ministerial expectations. The two that I found available on the EPA's website are for the years 2016 to 2018 and then more recently 2019 to 2020. Here we are in 2022, Mr President. So I do wonder if the government's finding it difficult to keep up with the current requirement. I wonder whether it's mere expediency that the requirement has been amended in the bill and extended out to 5 years to give a bit more breathing room rather than that decision being made and that extension being put there for any policy reasons. So I'd like to hear from the government if there are policy reasons for a 5-year timeframe for ministerial statements of expectations in the bill, or whether that's predicated on practical matters, that 5 years is more easy to achieve given that we currently find ourselves outside of a 2-year requirement. Mr Mr President, recognising the important role this bill is intended to play in protecting Tasmania's environment and the central priority of managing and mitigating the impact of climate change, which we have acknowledged just recently in the passage of the reviewed Climate Change Act for Tasmania, I wondered why there's no connection made here between the two. As raised by some stakeholders, there would seem to be an opportunity in relation to Clause 17, Part 7, Division 1B inserted, by expanding new Section 96P in relation to new proposed environmental standards. So I asked the government what consideration was given to requiring that environmental standards developed under this Act are consistent with any climate change action plans or any sector-based emissions reduction and resilience plans under the Climate Change State Action Act 2008. Mr President, we all know that our environment, our entire ecosystem, our biodiversity and ultimately our health and our economy is experiencing its biggest threat posed by climate change. And so I'm not sure why we would, I think, in some sense defy logic really, and probably community expectations, to be progressing and codifying a legally separated EPA, but not, which has a very significant environmental focus, without linking it to the efforts we have in other areas and through other legislation to counter climate change. Perhaps the government could provide some commentary on why there is no explicit link. Mr President, further on the issue of environmental standards, I'm interested to have some explanation of the review timeframe in the bill. The new Section 96W in the bill proposes a review of any environmental standards made within the 6-month period beginning on the 10th anniversary of the date of that any such standards came into effect. Environmental standards are pivotal to this bill and to the effectiveness of the EPA. It's really pleasing that they're going to be part of the mechanisms by which we regulate and monitor and protect our environment. Currently, it's proposed that the environmental standards will only be reviewed every 10 years. So, Mr President, that gives me pause, and I think that a decade between reviews of such fundamental elements of our proposed environmental regulatory framework is not consistent with requiring persons engaging in polluting activities to make progressive environmental improvements, for example, as one of the functions there. And it has the potential to lock in outdated standards or practices, or even just slide into outdated standards and practices. I don't know that it's consistent either with the intent of bringing greater transparency to environmental regulation, as the Minister promised during the House of Assembly budget estimates hearing on the 8th of June this year. It also doesn't invite the community to hold, and I quote, greater confidence in activities that use the state's natural resources and oversight of those activities, as espoused in this bill's second reading speech. Mr President, the only rationale I believe I've heard thus far in relation to this time frame of 10 years is that the environmental standards are somewhat equivalent to regulations, which generally have a 10-year review period applied to them. On matters relating to environmental protection, especially in the context of rapid impacts of climate change, it would seem advisable to have a review period shorter than a decade. A 5-year review potentially is more consistent with other major reviews that we have recently established in legislation, including in the new Climate Change Act, with the Climate Change Action Plans, the statewide climate change risk assessments and the sector-based emissions reduction and resilience plans all being set with 5-year review periods in that legislation. Mr President, before the break, I was just speaking about the 5-year, or about the 10-year review period for environmental standards, and questioning a rationale around that, and given 5-year reviews in other legislation we've recently passed. So I would appreciate from the government a policy explanation for the 10-year review period for environmental standards in the bill. And I'm open to being provided with a clear rationale for that 10-year period. But I have also prepared amendments that would reduce the period between reviews to 5 years, which I may then bring should we get to the committee stage. Mr President, in addition to what looks like an unnecessarily lengthy period between reviews of the environmental standards, yet I'm open to hearing the rationale for it, I also, though, see think it's hard to see why this review would occur behind closed doors, it seems, without involving consultation with the community or regulated industries. Perhaps it does. It's not specified in the legislation that has to occur. It's also of concern that there doesn't appear to be clear and transparent criteria by which the Minister considers whether to amend or revoke the environmental standards. So I'm wondering about the absence of those and whether there would be such criteria somewhere, perhaps not in the legislation but elsewhere, so we could understand how that decision is made about whether to amend or revoke, for example. I don't consider it appropriate or desirable to sort of cobble together something in form of an amendment to try and insert that sort of thing into this bill, and I haven't done that. But I do think that there's some serious concerns there about the omission of such evaluation criteria behind the decision making. And I'd like to, I guess, hear a bit more about that from the government to allay those concerns. Perhaps it's something the government would consider if they are to be developed, such criteria, putting them into the public domain in a different way, not necessarily within the legislation, and if that's the case, the government could explain where that might be found at a later date. Mr President, I have another potential amendment that I may bring should we get to the committee stage, which also seeks to improve transparency and community confidence in line with the bill's intent. And this time it's in relation to the technical standards, which the bill proposes to be the responsibility of the EPA Director. And while I have just spoken about the decade-long period between environmental standards reviews being potentially too long, that's certainly better than none at all. And from the legislation, it appears that that's the case for technical standards, that there isn't actually a review period legislated and mandated there for those. I don't see that in the bill. Perhaps I can be pointed to where it might be otherwise. I'd certainly be interested to hear an explanation from the government as to why there's not a built-in review period that's legislated or mandated, and if there is to be a review period, I'd like to understand what that will be and what that will look like, what the process will be, and depending on hearing some information around that, that will help me understand whether I wish to move amendments if and when we get to the committee stage. Certainly I would have thought that review periods for the technical standards, which sort of align with the environmental standards, would there'd be some natural synergies between the two and that they should be linked together. It must also be clear, Mr President, that the couple of those amendments that I've just mentioned, and which I may seek consideration of during the committee stage, from my view doesn't address all identified concerns and shortcomings of this bill before us. And as I've just alluded to as well, I don't believe it would have been appropriate for me to cobble together amendments to try to meet some of those concerns, much as I hold the concerns. I think it needs a more significant review and rewrite, potentially. And in respect to that, I do wish to draw attention to recent commitments placed on the public record by the government regarding a more comprehensive review of the Environmental Management and Pollution Control Act of 1994. Those statements on the public record include one from the Minister from Tuesday the 25th of October this year, where the Minister said, as I have noted previously, the government has flagged an intention to conduct a more comprehensive review of the Principal Act in due course. And he also said, we know our Act overall needs some review, housekeeping and bringing up to date. And further, my suggestion for them would be that the full review of the Act provides the scope to do that at a point in the future. So, Mr President, those sentiments appear to be in accordance with what we would have seen too in the Tasmanian EDO's submission to the bill, the draft bill, as well as their latest correspondence to all members in this place from the 7th of November, which stresses that we consider the following, and I quote from their correspondence, suggests that we can support EDO's recommendations for a thorough and independent review of the Environmental Management and Pollution Control Act 1994 to determine whether the Act is consistent with best practice and modern environmental regulation. So, given the Minister's recent repeated reiteration on the public record of some future intent to undertake the requested review, I've got a fairly clear and specific question for the Leader. Can the Leader provide a firm commitment from the government on two things in relation to that? Well, firstly, confirm that a comprehensive and fully consulted review of the Environmental Management and Pollution Control Act 1994 is to be undertaken within this term of government. And the second one is to confirm whether such a future review will involve further consideration of the independence, the purpose, the structure, the governance of the EPA, no matter the passage of this bill potentially this week in this place. So I'd like to hear about those two things in relation to a broader review. Mr. President, I think it will be very beneficial for our understanding of where and how this, as I've described it, relatively limited revamp of the EPA as set out in the bill before us fits within perhaps an overall more long-term legislative reform plan or reform plan that the government has in this space. So, and Mr. President, I do have one further detail I would appreciate some clarity on from the government, and that's a description around where, under the changes proposed in the bill and this new model for our EPA, matters around review. Who can appeal any EPA decision under this model? To whom can they appeal decisions? And where is that process documented? So just some clarity around how those mechanisms work under the new arrangements. I'll mention here too, I'd made a note as I was looking at this bill and then referring back to the Principal Act. I did note, and we've discussed this in relation to another bill today, I did note that there is binary gender language in the Primary Act, a number of occasions where he, she is mentioned. So again, it was pleasing earlier today to have the commitment from the government to potentially look at making it a matter of course that as we're considering amending primary legislation, we
Mr.
update.
President, just for clarity, I made the commitment that I would ask
put it to the Premier. Thank you.
Have a look at it.
Indeed, and that's as much as you can do, and we appreciated it. So it seems a good idea as we're amending existing bills. It becomes a matter of course, so we can tie them up.
Amendments that we put forward.
Well, we have amended it in some legislation as we've gone, but it's sort of messy if we have to do it ourselves. It'd be great to have it built into every process as it comes through. So, Mr. President, I acknowledge that the government put this bill out for public consultation and there were 11 submissions received to it. One of them was a comprehensive submission from the EDO, and I've referred to a number of matters raised in that submission. They do, as we can see in correspondence we received, members would have received from them, they remain frustrated that some of their feedback doesn't appear to have been taken on board, although some minor changes were made in response to it, so there was some response there. I certainly believe that it's worthwhile to have expert external input like that, and for us to be continuing to be informing ourselves from those external sources. I know that the EDO locally here has expertise from staff members who've worked in EPAs in other jurisdictions, for example, so this was something of particular understanding for them. So to conclude, Mr. President, it's worth noting that the legal separation of the EPA from the department is a positive step forward, I think, towards full and effective independence. I think there's still some distance to travel in that path. And further, there's some positive attributes to the bill before us, which we can certainly acknowledge as improvements on what had previously been in place. However, it would be remiss of us to ignore the detailed and considered feedback, I think, from legal professionals who engage and work in that space on a continual basis, as I've just mentioned. I do believe that the parameters set by the government for this reform were fairly narrow and modest. And while I do not agree with the setting of such a limited reform for something that is so long awaited and of such consequence for our state, so critically urgent given the pressures on our natural environment, I can but hope that this legislative confirmation of the legal separation of the EPA from the department is a harbinger of further timely, comprehensive review and reform down the track. So on that, Mr. President, I note the bill and will be interested for further discussion should we get to the committee stage.
Honourable Leader.
Mr. President, I seek leave to move a motion without notice relating to the suspension of sessional orders relating to the 4 p.m. break.
The Honourable Leader seeks leave. The question is leave granted? Those of that opinion say aye.